S Davar Co, which is one of the oldest and one of the largest intellectual property law firms in India. To start with, I would like to ask Professor Pankaj Mishra to address the audience and tell us about NVCTI, the center, and its activities.
Yeah, thank you. Thank you, Niharika, and good evening to everyone. First of all, I would like to thank Indira ma'am, who readily accepted our invitation on a very, very short notice. We discussed about today's talk a day before yesterday in the evening, and she was immediately, she gave her consent. So I am very, very grateful to her for
कहाँ धोनी रे कहाँ से धो लेली मछली का है कने है का मछली धरल जती अब आज न कल अपन दुल्हवा एक दिन
I suppose there has been some internet issues with Professor Mishra. I would like to proceed with the event. I would like to invite Dr. Indira Banerjee here with us. She is a senior attorney with L S Davar Co. She has delivered various lectures on IPR and participated in panel discussions, in seminars, and in workshops. Today, we are going to talk about intellectual property rights. Intellectual property rights are the rights given to persons over the creations of their mind. Intellectual property protection is critical to fostering innovation. Without protection of ideas, businesses and individuals would not reap the full benefits of these inventions and would focus less on research and development. I would now like to hand over the expert talk to you, Dr. Indira.
Thank you so much for the introduction, and a very good evening to all of you. In this session of today's evening, I will be talking on intellectual property rights and innovation, technology transfer, and so on. But before I get into it, I would like to thank the organizers. Although Dr. Just 1 second, I will.
I'm extremely sorry. I got disconnected.
Yes, sir. Yes, sir.
Yes,
we proceeded with the event, sir.
Yes, I think, so let us start. I think it is good that we should proceed with the event.
It's okay if you would like to add anything more. I mean, would you like to continue or should I start?
No, no, ma'am. I think the break has taken time. So we will start with the proceeding and then we will talk.
Okay, okay. So I would like to thank Professor Pankaj Mishra for giving me this invitation to be here with all of you today. I'm really grateful for that. And I had the opportunity of visiting your lovely campus about 3 years back. I think it was 2017 when I went. And there, I really like the environment, and it's a sprawling campus. It's just beautiful. But this time, due to the current situation with the threat of corona and all, we are all so scared to step out of our homes that maybe again next time when there is another seminar, I will take the opportunity to visit you once again and get the chance to meet all of you. So today, let this be an online session, and I will start my talk on innovation, technology transfer, and intellectual property rights protection. I will try to make it as simple as possible so that it is understandable and clear to even the layman. So this is not really such a way, although the commercialization of IPR is quite a complicated matter, but I will do a very simple, straightforward run of the entire talk. So this is innovation, technology transfer, and intellectual property rights protection. Now, when we talk about innovation, what do we understand by innovation? It is the creation of new ideas or processes which will lead to a change in an enterprise's economic or social potential. So, the basic idea behind any innovation is that finally the inventor, the innovator would like to reap some commercial benefits out of it and maybe make a name for himself in the society. So it will lead to a change in an enterprise's economic or social potential. This was said by Paul Drucker, and this is a very straightforward, I would say, summing up of the whole situation. Otherwise, why would anyone make an invention? Why would anyone try to get it protected by the legal frameworks available? It is all because he wants to reap some economic or social benefits from his innovation. Now, how do we classify the different kinds of innovation? There are innovations which are simply new to the laboratory. There is a bigger invention which is maybe first to the country and no one has heard of it in that country. So it has a slightly greater degree of innovation in it. Or it could be first in the world. So that is a bigger innovation. Or it could be an incremental innovation of something which has already been done before. So that is also an innovation. Or it could be a radical innovation, like, for instance, when the wheel was invented for the first time, that was the greatest innovation of all. So we cannot simply say it is an innovation. There are different degrees of innovation by which we can actually see how it can be protected in the best possible manner. So first we have to classify what degree of innovation has taken place. Now, once an innovation has taken place, the idea is to transfer that innovation into a form by which I can reap some benefits of the innovation. So the process of converting ideas or scientific findings from research laboratories into useful products or services for the commercial or public sector, that is what we mean by technology transfer. So commercialization, it can be defined as the process of turning an invention or creation into a commercially viable product, service, or process. And it may require additional R&D product developments. It can require clinical trials if it is a pharmaceutical invention, or development of techniques to scale up the production from the laboratory scale to the industrial scale before taking the results of the research out into the market. Now, simply speaking, commercialization of IPR refers to making your IPR marketable and earning profits through it. That is the basic idea. So the objective is to take the scientific and technological developments to the realm, to the domain of to an extensive array of users, so that they can further develop and use the technology in the development of new products, processes, applications, and services. So that is the basic idea. Now, imagine you have a piece of land. You can get it valued. You can get it valued by a valuer, and you know exactly what price it will fetch if you sell it. Or if you lease it out to a farmer for tilling the land, you know exactly what price he will give it to you as the lease money. But how many of us know the exact price of the patents or the trademarks or the copyrights that we own? We make an invention, we get it patented, but do we really know how much money it can fetch if we sell that patent in the market? Or how much money it can fetch if we give it to someone who will actually convert that patentable invention into something tangible? Supposing it covers a method of making a device, a method of making a machine, then he will actually produce that machine and sell it in the market. And fetch money. But are we really aware of the price of the patented invention that we are trying to sell, or maybe the trademark, the brand value of the trademark that we are planning to assign, or maybe the copyright that we are trying to sell to someone else? So it is not, as it is an intangible matter, as these IPR, intellectual property rights, as these are intangible matters, it is not really so easy to sell them in the open market, just as you are selling your piece of land. But at the same time, as these are assets, whether tangible or intangible, they can be sold like any other piece of tangible asset. Just as you sell your house, just as you sell your car, or you rent your house, you rent out your car, you can do the same thing with these intellectual property rights. So that is what we are going to discuss today, how to go about it, and what are the different things one should keep in mind when one does a commercialization, a transfer of his intellectual property rights. So this is basically, the objective is to take the scientific and technology developments to the reach of the user, who can actually further use that invention, use that technology, or further develop on the technology, and for the development of new products or processes, applications, and services. And what kind of products or processes are we looking at? These are all information-based products, because they are products of the mind. So they can actually be works of fact. For instance, they can be an invention, they can be know-how, technical data, or data maps. They can be works of function, for instance, mechanical devices, a car, a motor pump, a geyser, an air conditioning unit, whatever. They can be electronic circuits for running these units. They can be works of form, for example, designs of objects which do not have any mechanical function, like jewelry and graphic designs, and so on. So these are the different forms in which these information-based products may be made available for transfer. But at the same time, once we have the information and try to convert it into the information-based products, we will also have to look at the information. We also have to see whether the product has functional advantages, whether the whether the product is available at a lower price. Now, when we are selling a product, a new product in the market, unless it has certain functional advantages over the known products, why should people buy it? So it has to have some technical advantages. It should be available at a lower price. It should have a more attractive design. It should look better than the existing products. Or it can be covered by a reputed brand, because that is something, again, which we trust. If we see a reputed brand, we know automatically that, okay, there is some guarantee that the product will be good. Because the product, that brand speaks for the quality of the product. It speaks for the company itself. So we have a certain trust in the reputed brands. And the product should have a consistent quality. On repeated manufacture, it should not lose its quality. So that is what is important, that it should have functional advantages. It should be available at a lower price. It should have maybe an attractive design. It should be covered by a reputed brand, and it should have a consistent product quality. So these are the things that we look for in a new product which is coming into the market, and which maybe we are trying to sell to the people, or we are trying to sell that technology to a certain buyer. There are certain other questions too, which arise when these products are coming to the market. These are the intellectual property issues which arise during the development of a new product. Now, the very basic questions are, can the innovation be legally protected? I put in my entire effort, my revenue, everything into developing a new product. So I would naturally want to have a legal protection so that tomorrow, if someone else does not steal my product and get away with it, so can the innovation be legally protected? For how long? Because unless it is protected for a certain period of time, I won't have the benefit arising from that product. So I won't get enough time to get enough of returns from that product. How does one protect an innovation from imitators? How much will it cost? When should I protect my invention? Do you really need to rely on an IP expert, or can you do it yourself? So these are the various questions that come to the mind of the innovator, of the inventor, when he makes a new product. Now, the answers to these questions are again complicated by the fact that one or more types of legal frameworks may be used to protect a particular invention, product, or a process, or a creative work. So it frequently happens that a single product can be protected by various forms of intellectual property rights. Now, having said that, I would like to just talk about the different forms of intellectual property rights that are available to us. That is by way of patents, designs, copyrights, trademarks, or geographical indications, that is appellations of origin. You must have heard about the Basmati or Nagpur oranges or Kolhapuri chappals. These are all protected by respective geographical indications, and that is they happen to come with a certain flavor from that particular area. It is typical to that area. So for the thing is that if there is a single invention, like for instance a television set, the television set has a certain circuitry, has that mechanism, the electronic system, everything, which can be protected under patents. Now, if it has a nice look, if the design of the TV is new and then it is different from earlier television sets that were there in the market, then one will naturally want to protect that also, and that will come under the protection of industrial designs. Then, if there is this TV is covered by a reputed brand, for instance, Sony or Philips, or like we used to have in earlier times, we used to have the ECTV. Now we have various others, the TCL and all. So these are reputed brands which are protected under trademark registrations. So there are different forms of IP. Then there is the internal circuitry, which can be protected under the Topography of Internal Integrated Circuits Act. So you can see that there is a host of different intellectual property rights which are actually used for protecting that single television set, and each of these are important by themselves. So you can have a patent, you can have a trademark registration, you can have a design registration, you can protect the integrated circuit, and you can have a copyright for the software that runs the electronic circuitry. So these are the different types of intellectual property rights which can actually protect the different areas of this particular invention. But after you make the invention, the important thing is to have the technology transfer, and that is what is the topic of today, that we have to have a transfer of the technology and reap benefits, that is commercialize the invention. Now this is from invention to commercialization. It is a multi-step process, because today you make the invention, it is not possible to get it commercialized tomorrow itself, because there are different stages through which it has to run. That is, the first step is finding the invention or inventor. You have to actually trace the invention and the inventors. Then you protect it of these intellectual property rights. Then you assess how much weight this intellectual property right has, whether it is actually good enough for commercialization. And if it is found that this is really good enough for selling to somebody who can actually bring it out in the market, then you develop on that intellectual property and make it sale worthy. So that is the next step. After that, you do a commercial evaluation to actually see how much profit that intellectual property right is going to fetch, and then go through the various commercial routes available of sharing the invention, that is either by way of selling it or way of renting it out or whatever, or leasing it or mortgaging it. So these are the different areas, different types of transfers that take place for commercialization. So between an invention and that commercialization, there are different steps, and we will do it one by one. For instance, we come to the first step, finding inventions or inventors. Now, we have to first see what is the invention. That is very important. What problem does it solve? This is important because we have to actually find out what problem it seeks to solve, because that is where the invention lies. And that is where it will actually be, whether it is patentable or not, that is judged by whether it can solve some problem in the prior art or not, whether it is inventive enough. What is the stage of development? That is whether it can be, whether we can now actually go for IPR protection. Is there enough data for protection? Has anything been published, or is it ready for publication? Because it is very important to check publication before a patent application has been filed. Because your own publication, we know that in a research institute or people who are doing their PhD or publishing papers, it is very important to have publications in your name. But at the same time, if it is to be patentable, one has to stop publication, first go for a patent application, and then finally get it published. Because your own publication can destroy the novelty of your invention. Then there are inventor issues which come up, inventorship issues. So it is important to actually identify the owner of the invention. Who owns the invention? Is it the institute? Is it the funding authority? So those things have to be very clear. Who paid for the research? Sometimes these like UGC, CSIR, they are the funding authorities, they pay for the research, and the invention is naturally assigned to them. So that is also very important to see who is paying for the research and where did the research take place. This is important because if there is a person, a foreigner, or if there is a person who has collaborated with you and has actually done the research on foreign soil, then, or he has done the research in India and you want to file the application abroad, then it is necessary to take permission from the controller of patents before such a person can actually file his application abroad. So there is again this problem that if somebody who has made the invention on Indian soil and then the invention has to be filed abroad, you want to file the application in a foreign country in the first place, then the Indian controllers, the Indian Patent Office has to issue a permission, and only then can the invention be patented abroad. So these are the different issues that have to be first looked into before to sort out the invention, patentability issues and the inventorship issues. Then after that, once these are the answers to these questions are available, you go for protecting the intellectual property. Now, protecting the intellectual property is possible only if the invention is patentable. If it is a patent, if it's an invention, it has to be patentable and it has to satisfy the provisions of novelty. It has to be non-obvious, that is, it has to have an inventive step, and it has to have industrial applicability, because a patentable invention is not like what we do in journal publications. It has to, either there is an industrial applicability, the patent is not likely to be granted. It is not only for academic interest, it has to additionally have an industrial application. Then one has to see whether there are other ways to protect it, for instance, by copyright, trademark, design, or trade secret. And each form, which type of IPR is appropriate. And again, in each country, this varies. Like what can be protected under patents in USA cannot be protected under patents in India. For instance, software patents. We cannot have software patents in India, but in the US, such patents were available for a very long time. So this is what I had said earlier, that intellectual property rights are of different forms. For instance, patents, trademarks, designs, copyrights, geographical indications, trade secrets, layout designs for integrated circuits. And it is for you to judge and see which forms of IPR are available, are required for adequately protecting your invention. This is the example I gave you. Patent is available on the remote control mechanism, maybe. It is valid for 20 years as a new technology. Trademark can be protected for 10 years from the date of registration, and it is renewable for the entire lifetime. Copyright on the software, it can be protected under the Copyright Act. Protection of layout for Integrated Circuits Act, that is the integrated circuits can be protected under this act. And the design, the look of the TV set as a whole can be protected under the design law. It is valid for 10 years initially, which can be renewed for another 5 years. So there is a total of 15 years for which the design registration is valid. But in going for a patented invention, there are certain constraints, particularly for filing patents in India. For instance, there is the novelty bar, there is the inventive step requirement, there is the industrial applicability, as I've already said before. In addition to this, there are certain other problems. For instance, there are non-patentability issues defined under clauses A to P of Section 3. Then there are disclosure requirements under Section 10. Then the NBA requirements for these are the National Biodiversity Authority, where the requirements where if a biological material is used from India, used in the invention, then one has to seek permission from National Biodiversity Authority to work the patented invention in India. And unless that permission has been obtained, the patent, even if all the other criteria are met and it is patentable, the patent will not be granted till such time the NBA gives that certificate, and a copy of the certificate is filed at the patent office. That is one. Then if the invention uses traditional knowledge for Ayush, that is the Ayurveda, Unani and naturopath, Siddha, homeopath, all these types of different medicinal forms. So if anyone uses traditional knowledge which comes under Ayush, then this will not be patentable. Anticipation under Section 13, that if the if the application that is filed, if the invention is already known from earlier publications, there are certain different criteria for that, then it will not be patentable. So these are the different restrictions on the filing of patent applications in India. There is a Section 3C where a discovery of scientific principle or abstract theory is not patentable. So if you have a mathematical formulation, if you have formulated a scientific principle, then that is not patentable. A mere discovery of a new form of a known substance, or a new use of a known process, or new use of a known machine, new use of a known apparatus, these are not patentable unless there is at least, so this, as you are mostly, you mostly deal with mechanical and civil and electrical matters. for you, the relevant part will be the mere discovery of a new machine or apparatus, or the mere use of a known process, machine or apparatus. So that is not patentable for you. Again, there is a section 3E where a composition is not patentable unless it can be proved that the composition has certain properties which cannot be predicted from the mixture in the composition. If a composition comprises of A, B, and C, then the A, B, and C constituents, then the composition should have some property which is different from the aggregation of the properties of A, B, and C, and it should have some other property D, which makes it different from the aggregation of these components. So this is again not patentable. This is mostly applicable for compositions like building material compositions, polymer compositions, pharmaceuticals. So if you are in the process of making any such composition which involves mixing 2-3 different components, then it is always better to find some property of the composition which is not predictable from the properties of the individual components of the composition. Then section 3F, where a mere arrangement or rearrangement or duplication of known devices which can function independently of each other is not patentable. That is, for instance, a torch with a writing device. You switch on the torch and start writing with that pen, then that is not a patentable invention unless there is some mechanism by which as soon as you start writing, the battery is switched on and the torch starts functioning. So there has to be some kind of interdependence of the different parts of the device which make it patentable. Mathematical, under section 3K, a mathematical or business method or computer program or algorithm, this is not patentable naturally. So it means software, methods of online trading, internet banking, these are not patentable. Section 3N is makes this not patentable. That is a presentation of information. Maybe you have collected sample data and compiled it into a form and making some reasonable analysis from it and giving out some conclusion. That is simply a collection of data, although you have put in your own inputs and made an analysis and you're coming to a conclusion. But this collection of data and compilation, that will still not be patentable. This can go under copyright protection. Section 3O, which debars topography of integrated circuits from patent, because there is a separate act under which the topography of integrated circuits can be protected. So these are the different constraints of filing patents in India. But taking into consideration the fact that a patent has been obtained, then if you can overcome all these barriers and finally obtain a patent, then these IPRs are not only a legal asset, they also represent a commercial value and can thus be a financial instrument. So that is a very important thing. And how can they be a financial instrument? Because they can be sold, they can be licensed, they can be used as a collateral or security, they can be mortgaged. So these are the different ways in which an IPR can be exploited to give you commercial benefits from it. So we now come to the next step, that is intellectual property assessment and intellectual property development, which means assessment and development is to develop, like you assess the market potential and try to develop the IP which has more commercial potential and in ways which will enhance the chances of success in commercialization. So that is important, that an IP which has more commercial potential, you try to develop that IP in a way which will improve its chances of success in the market. And then you identify the industries which may be interested in that technology covered by the IP, so that the industry can buy the technology from you, can buy that patent from you and develop the product and then sell it in the market. And in lieu of that, either they give you a lump sum remuneration, or by way of, or they can give it to you by way of a royalty, which can come to you in stages as and when the product gets sold. So these are the different ways in which the product can be out in the market and given to the industry. So, and what is the other assessment that you have to do? You have to decide whether the time is right for commercialization or whether you should wait a little bit more and then give it out in the market. But again, the risk is that if someone else is developing some similar product, maybe that he will go to the marketplace before you. So as soon as you have come up with a product, come up with an innovation, with an invention, and it is covered by the intellectual property right, and you think that this might give you good results, you have made a market assessment, you have found the industries which may be interested in buying your product, then you should immediately approach the industries and try to get your intellectual property right on the road for market for sale. Then there are other considerations too, that if the response is not so good and you think that this intellectual property right may not give you such good results, then you have to take a decision as to whether you want to continue with that IP, continue with the development of the IP, or you will shelve that project. So if you continue with the IP, you have to keep on paying the renewal fee every year, which is quite expensive. And if the IP is not giving you good returns, then it is always better to shelve the project. But again, there is another consideration. Today, you don't have the market for that particular intellectual property, that particular invention, but who knows? Maybe within a year or two, the market will come up. So there you have to take a prudent decision, because when a person makes an invention, he should also be aware of the marketplace, that whether that technology is a saleable technology or not, or whether there is a future prospect in that technology, and then that will make and then take a decision as to whether he will stop that project or whether he will continue with it for maybe a couple of years more, just to see whether that technology can be sold maybe within 1 year or 2 years. And that decision has to be taken by the person who has made the invention, or who is the person who is in touch with the market to sell the invention. So then comes up the question of commercial evaluation, because unless you actually commercially evaluate your product in the market, you will not know whether you want to shelve the project or whether you want to continue with the project, and how much commercial benefit will accrue from that particular project. So then you go for a commercial evaluation of the product. This is a very complicated exercise, because there are various aspects to be considered. The very straightforward aspects are market attractiveness, whether it is attractiveness. I do not mean it looks attractive, whether it is an attractive, technologically attractive product for the market, whether it is a technologically attractive product for the industry to buy and develop on it further, whether the industry will consider it to be good enough to develop and manufacture it so that it can sell it finally, whether there is a competitive advantage of that product over known products, and whether that is sustainable. That is, it's important that it has a sustainable competitive advantage over known products. And the target segments, whether it will target definite segments of the industry. It's important to find out which segments it will target and the benefits and advantages from that particular target segment. So there are certain methods which are intuitive, and then there are mathematical models also. There are economists who actually deal with these things. So it is a complicated calculation which might give you some insight into the commercial value of a patented technology. But at the same time, there may be a lot of calculation and mathematical evaluation and everything, but the actual value of the technology can only be assessed once it is commercialized. It is not possible to actually assess the exact value of a technology unless that technology is actually being sold in the market. So final exact value will only be, you will only be aware of the exact value once it is out in the market. But still, a commercial evaluation is important just to see whether you want to continue with the product, whether you, and also to actually assess the price at which you are going to sell your patented technology. You have to assess, because for a house, it is like you get a valuer, you get the current market price, and then you can assess the value of the maybe the apartment that you want to sell. But for a patent, it is not such a straightforward calculation, and it requires a lot of other inputs as well, which will give you, but which will still give you just a roundabout value of the product. It will not give you an exact value. So the IPR holder, if he has a certain number of patented inventions, it increases the value of the IPR holder. A better IPR portfolio will give you a competitive edge, and it will attract venture capitalists. It will attract funds for further research from the funding authorities or maybe companies with which you are going, if you go for collaborative research or contract research with different companies. So this is, if you have a better IPR portfolio, this will definitely give you an edge over others in attracting finances from different sources. Now, IPR, since it is an intangible asset, it forms a substantial part of the assets of a company or an institute and increases the valuation. As it is for a company, similarly for an academic institute also, if the IPR, if it holds a number of good intellectual property rights, particularly patents, and because trademarks for a institute is not so important, if it has a good number of patentable inventions, then that can actually help in expanding its, I would say, the marketability of the patented inventions, and actually attracting funds for research and for going in for collaborative research with different companies. Because nowadays, the main thing for the directive that is given to all academic institutes is that you have to earn your own. So it is important to have a good number of a good IPR portfolio to get it assessed by commercial evaluators and try and come out into the marketplace and get these IPRs commercialized. So we come to the last stage, where it is the commercial routes, the different routes by which it can be commercially sold. That is commercial routes for IPR commercialization. Now, an intellectual property may be commercialized by sale or by assignment or by entering into various types of contractual business relationships, such as licensing. So there are two ways in which it, just as you, if you have a house, you can either sell it, get a lump sum money for it, or you can rent it out and get the rent over a certain period of time, so that or you can lease it out to somebody, get a lump sum money for that period of lease. So these are the different ways in which you can exploit the apartment or the house that you have commercially. Similarly, for intellectual property rights, you can either sell it or assign it, get a lump sum money for that, or you can enter into various types of contractual relationships, such as licensing, where you get where the royalty is paid to you over the period of through which the license is valid. Or these are the main two ways in which it can be transferred. The business vehicle by which this is done may be by way of partnership or a joint venture or a spin-off company. And IPRs act as the legal vehicle through which this transfer of knowledge is effected. This contractual relationship, this transfer of knowledge is effected through the vehicle, the legal vehicle, which is the intellectual property right, and it has to be embodied in the form of a agreement or an assignment deed. So that is the instrument. So there has to be an assigner or a licensor, and there is an assignee or a licensee, who, that is, the assigner gives and the assignee takes it. So for a sum of money, the assignee buys that intellectual property and gives the assigner a certain amount of money for it. And the terms and conditions are laid down in the instrument, which is the deed of assignment. Similarly, if there is a license under the patent, the licensor, that is the patentee, he will license out the patent to one or two or more licensees, and the terms and conditions will be embodied in the license agreement. And that has to be, and all these deeds and licenses and agreements have to be registered with the patent office, because the patent office should be kept aware of any transaction that takes place under the patented invention. So alternatively, there can be other types of exploitation or commercialization of the invention. It can be an in-house exploitation where the inventor himself wants to exploit his invention, so that the owner himself wants to exploit the invention, that is in-house exploitation. He can also create a new business for himself and sell it himself. But in that case, he has to consider a lot of other factors as well. This approach definitely comes with the best returns, and but it is also the most risky, because if it is a success, well and good. But if it turns out that it is not so successful, then the risk is on the person himself, and he has to bear the entire brunt of the exercise. So these factors on how it can be developed into a desired product, which can be sold in the market, and the funding required, and everything that has to come in for exploitation of that invention, has to be done by the owner himself, and which is a bit of a risky proposition. Particularly for universities and institutes, it is not really possible to go for in-house exploitation of patents, because you are not the people who will do any business with the academic results that have come out. So what for you, it is a better option that the invention be either sold, or it be licensed out, or it be given to any company for further development. So that is how mostly the institutes and universities, they function. They do not exploit the invention in-house, but rather they would like to assign or license out the invention. So in an in-house exploitation, the advantages are that there is a complete control of activity over the entire patenting and the marketing procedure. The returns are not shared with other parties. Everything goes back to the owner, and he retains the ownership of the IP. He does not have to license it or assign it to anybody. But the disadvantages are that the resources, skill, and a lot of resources, skill, and investment is required for exploitation of the patent in-house, and he has to take all the risks by himself. Now, if he wants to develop a new business with it, then advantages are that there is a lot of flexibility, because he is the owner, it is his business, so it's a flexible situation. He can raise a lot of significant investment while retaining control over the IP. There is a limited liability, and it is a good system for for people with a lot of revenue for large opportunities. But the disadvantages are that it is time consuming, because, for instance, like for biotechnological inventions, one has to go get in touch with collaborators so that the invention, because biotechnology takes a lot of time in development. So if you're getting in with collaboration with some other collaborators, it might be a time consuming effort because they will develop the invention and then come back to you. So it is not a very feasible situation because it takes a lot of time. Then time is money. So the more time it takes, the more the funds that will be required. There is a lot of creative effort required. And he has to have a focused management of the entire process, which is difficult. It is not suitable for small opportunities. Now we come to the next stage where the invention is the owner of the IP decides to sell or assign his invention to a third party. So at least in theory, this is it requires the least effort, because what you do, you just you take your patent, you get into negotiations with a third party, draw up an assignment deed and sell it to him. And there is a quick return also, because one of these because as soon as you the patent is sold for a lump sum, you get the value immediately, and you don't have to wait up to 20 years to wait to progressively get the royalty on the patented on the marketed product. So an immediate quick return on the product, on the invention. There is no long-term liability, because if tomorrow something goes wrong and the patented invention does not really work out as expected, it is not proper, it does not attract so much of market as expected, the owner does not have any liability because he has already sold his patent. So there is no liability on the owner of the patent, even if the patent does not give results as expected in the long run. There are no further obligations because he has sold off his patent for a sum of money, and he is under no obligation if anything goes wrong tomorrow. And the negotiation is very simple because it's just between two people, the assigner and the assignee. For a lump sum amount of money, the assigner just sells his patent to the assignee. But what are the disadvantages? That the assigner has already sold his invention, so he does not have any control over further development of the IP. Either there has to be a clause in the assignment deed that at some point of time, if there is a further development of the IP, it can be back assigned to the owner. But otherwise, he does not have any control over any further development of the IP. If he wants to use his own invention, which he has already sold, and develop on it further, he has to take a license from the assignee, and only then can he use that IP for further development. So that is a disadvantage. And this may curtail future avenues of inquiry, as it is already sold. And if the assignee wants to do further work on it, and if he is that is good. But if he is not interested in expanding on that intellectual property, if it holds a lot of promise, but the assignee is not really interested in further exploiting that or developing that IP, this will curtail any future avenue of inquiry on that particular patented technology. And relatively low returns, because at only in the first instance you get a lump sum amount of money. But if the patented invention is really doing good in the market, then there is a recurring royalty which you are missing out on, because you have already sold out your patent in the first place. So that is, in that sense, it will give you a relatively low return if it is a very good invention, and if it shows a very good promise in the market and gives a recurring profits to the assignee. So in that case, if you think it is a good patentable invention, good technology, and which you may think of developing on in the future, then a better thing to do would be to go in for licensing. Licensing is a right by which you give to the person who is taking the license. So you are the licensor, and the person who's taking the license is the licensee. So the licensor gives a license to the licensee and to work the invention. So it can be to a single licensee, in which case the single licensee has the right to use the intellectual property, and which can be also used by the owner. So that is an exclusive license under the patent. Or it can be a sole license where I'm sorry, if it is an exclusive license, it is given to the licensee, and the owner of the licensor cannot use the patented invention. But if it is a sole license, the licensee gets the right, but it also allows the owner to work the intellectual property. Or it can be a non-exclusive license, that is, allows the owner to retain the right to exploit the licensed property, and he can grant licenses to several licensees. That is non-exclusive license under the patent, where several licensees are allowed to work on that patented invention. For instance, if it is some kind of technology which requires a lot of where different it is a state of it is a technology which is there in the domain, and it requires a lot of companies to put in efforts to get the product, and it is something that is being practiced, something that is being practiced widely over in the market. Then it is not essential, but it is wise to give the license to different companies or different licensees, so that each one of them can work on the patented invention, and they can supply the necessary the volume of products that is necessary in the market. But if it is, so for instance, a pharmaceutical, where there is a lot of money which has been put in for maybe commercial trials and development of the product, then the company which is putting in so much of revenue for the development of the product will want an exclusive license to themselves for working the invention. So depending on the type of technology, the license that should be given can be an exclusive license, or it can be a non-exclusive license. Again, there can be something as a cross licensing, where, for instance, if both the parties have good intellectual properties, then in a mutually settled agreement, two or more parties, they can use each other's intellectual properties. So that is called cross licensing, where you give out a license to a party, take a license on some intellectual property owned by that party, and you get into a cross licensing agreement. Now, the important thing is in a licensing agreement that the returns on the product are linked to the success of the product in the market. There is a continuous source of revenue based on the sale of the product. It uses, like, if I'm to give a license to a partner, I will definitely look for an experienced partner who can handle the manufacture of the technology that is patented. I am not required to take all the risk myself. I'm giving it to a licensee who is going to manufacture and take all the risk in the development of the product. But at the same time, I'm not selling out my invention to him. I retain some control over the development of that product, and the returns are usually higher than for a sale if it is an exclusive license. But if it is a non-exclusive license, then definitely the the value is slightly less. And at the same time, the rights to the IPR may be regained once the licensing term is over. If I license it out for maybe 10 years, then at the end of that 10-year period, I can get back my IPR. But what are the disadvantages? I may have to negotiate with several parties if it is a non-exclusive license, and I have less control over my patent. Then upfront payment is less for an assignment. For instance, for an assignment, it's maximum. For an exclusive license, it is slightly less. For a non-exclusive license, it is still less, the upfront payment. Naturally, because with the lessening degrees of control over the patent, the price accordingly decreases. So this is the situation where a company in licensing is where he is taking a license, and out licensing is where he has the intellectual property and he is selling out he is licensing out his intellectual property. So the out licensing party assesses the intellectual assets that he has, the patents and know-how and everything, and the in licensing party identifies the gaps, that is what it requires, the technology that it requires, so that there is a licensing demand which is created, and the out licensing party will fill in that demand. Then there is a strategy which is decided. Both the parties decides on what is needed, and the party that gives the license decides on what it has to offer. Then there is a licensing terms and conditions and financial validity which is decided on, and that is the out licensing party has a synchronization of supply. And there is a synchronization of supply and demand between the out licensor and the licensor and the licensee, and that they come up with the licensing terms and conditions and the financial validity of the license agreement. Then the out licensing party makes an assessment of the valuation of the intellectual property that it is going to license out, and the in licensing party will also take stock of the funds or the financials that it has available with him, and then comes the decision on the licensing fees or the royalty in the license agreement. Then again, when both identify both their targets and goals and the returns on the investment, then there is a quid pro quo established, and it is a non-exclusive or an exclusive license. If it is a technology versus financials, then it can either be an exclusive license or a non-exclusive license. If it is a technology versus technology, then like what I said, it can be a cross license, because both the parties have two technologies and they license it out to each other. So there is a cross license which is established and the deal is struck. So this is how a licensing procedure will go. But at the same time, it is not such a simplified process as it seems. There are several rounds of discussions and evaluations with lawyers and all. And finally, the licensing strategy has to be established and the licensing agreement has to be drawn up. Have I exceeded my time?
Ma'am, we can extend the session for 5 more minutes.
Okay. I'll quickly try to sum up. So there are other important aspects of commercialization which have to be looked into, like IPR valuation. Like I said, there has to be a realistic IPR valuation, and that helps in optimizing the IPR portfolio and increases the return on investment. An IPR audit, that is, it helps in identifying the IP generated by the institute and or the organization, so that there is an IP audit of the existing IP and ownership and historical relationships related to these properties. Then it should include the scope of protection of the IP in the audit, and also devise a formal strategy by which the owner can actually terminate the assignment, terminate the license term if there is any problem which arises during development of the IP. So the exit clause is very important in a license agreement. IPR due diligence helps in locating IP assets and evaluating the benefits and risks involved in the use of such assets. Very frequently, when a company goes into a merger or acquisition, there is an IPR due diligence that is conducted, and that helps in assessing the net worth, the IP assets that the company owns, and the net worth of that IP asset. But a very important thing is, all this would be meaningless unless there is an enforceable, unless the IPR is enforceable. That is, if there is a good product in the market, there would be naturally people who would try to simulate the product and bring similar products in the market. So it is important to resort to effective enforcement of IPRs. That is, if there is a person who is infringing on the product, then it is very essential that there be means by which a condition there is some means by which an injunction can be drawn up, or if either a permanent injunction or a temporary injunction, and the imitator or the person or the infringer can be stopped from making further damages and by copying the inventor's products. So it is important that the legal system, legal framework be in place for successful enforcement of the IPR. Otherwise, all these exercises are quite meaningless. Since we don't have the time, I will skip the case study. Anyhow, this is just I think you can also look up on the net if you want to. This is a company which was called NICOMED. The NICOMED strategy for it came up. It really came up within and made a very marked global presence within a very short span, just by virtue of a very good IPR strategy, in licensing, out licensing, by publication, or making proper deals, and also disposing of with patents, just sort of abandoning patents which are not useful, and maintaining a proper, good, well-maintained, well-reviewed patents strategy. So by all this, they really made their global presence and was at par with any of the big pharmaceutical companies like Merck and Forest Laboratories and all. So this was the story of NICOMED, which just by virtue of a very good IPR strategy, IPR commercialization, they really made their presence felt in the global market. So I think I have covered more or less all the aspects. And if there is anything that you would like to know, you can ask me. Otherwise, thank you very much for a very patient hearing.
Thank you, ma'am, for this amazing and wonderful session. Before we move on to the Q&A session, we have a few questions with us. Before we move on to the Q&A session, I would like to invite Professor Pankaj Mishra, Head of NVCTI, to tell us more about the center and its activities.
Yes, Niharika, thank you very much. Actually, I think we know already about the NVCTI, but since Indira ma'am is here, I would like to reiterate it again, that we have, ma'am, actually created a new center which is called Naresh Vashisht Centre for Tinkering and Innovation, and which is coming up in our institute campus in an area of 11,000 square meter. And this center is being funded by our alumni and Sri Naresh Vashisht ji. So that's why the name. So this center is basically going to have a very well-equipped center of state-of-art laboratory, which will be available to our student as well as to the innovators from the society. So the basic purpose is to push our student and to provide them opportunities where they can use their creativity and to come up with products which leads to patent as well as to new entrepreneurial ventures. So that is our whole objective, which is, and along with that, we are we are actually involved in lots of activities, student-driven activities, to promote some innovative ecosystem in the campus itself.
Okay.
So these are the things which we are doing right now. So, but this talk is one of the major thing which I wanted to do for long, because the IPR is something which is very important if the center has to rise. So that's all which I wanted to tell at that point. So thank you,
Thank you
Niharika.
so much.
Go ahead with
And
the questions.
thank you.
Yes.
And it was really interesting. I mean, hearing about your center, because ISM does come up with a lot of good inventions. So if you have some a place where they can actually go ahead and actually try to manufacture
Yes.
the
Yes.
technology, that is really going to help them.
Yes.
And
Yes.
if
Yes.
there is any help required from our side, we are always there. So
Of course. Yeah. Of course. Right.
Thank you, sir. Ma'am, we'll be taking up a few questions now. Our first question is from Professor Niranjan Kumar. He is asking, is it mandatory to publish related papers after the submission of patent? Whether previously published paper will be considered as output of the patent or not?
it is not necessary to publish any patent papers after the on the related technology after a patent application has been filed, because these things are mutually exclusive. A patent has nothing to do with a published paper, and a published paper has nothing to do with a patent. But it is important to keep in mind that a patent application should be filed before a paper is published on that invention, because if the publication goes out first, then that same publication can destroy the novelty of your patented invention. So that will be considered as prior art. Your own publication will be considered as prior art once you try to file your patent, you try to get your patent application granted.
Thank you, ma'am. Our next question is from a student. He is asking, how long does it take an invention to be commercialized, and does the design of the product help in the protection process?
Yes, the design of the product, like I said, a design of the product can be protected under the Industrial Designs Act. So if it is only the product design, I don't know whether he means the mechanical design. If it is simply the appearance of the product, then it can be protected under industrial designs. And if it is a mechanical design by which the technology, it is an improved technology, then it can be protected under patents. And commercialization, how long it will take is difficult to predict. But if he is aware of the marketplace, and if he knows the potential industries which will be ready to buy his invention, then it should not take very long, because these discussions should be completed as soon as possible, so that other players don't step in the market. So maybe within a year or so, he can actually go after the invention is protected under patents, he can go in and get it commercialized, talk to different industries and all, and get it commercialized. It should not take very long.
Thank you, ma'am. One of our newest students from batch 2020 is asking a very simple question, but I would like you to answer it. He's asking about what is a portfolio?
Means the array of different intellectual properties that you have. You may be having 2 patents, then maybe a copyright on the software that is covered by that particular software is under protected under copyrights. Then maybe you have something, the design of that particular article that you have made, or some other technology. So all the different forms of intellectual property rights, maybe 2 patents, one design protection, one registered design, one copyright. So all this is the portfolio that you have. Like when you have to submit something, like people who go in for the artists and all, who have to present something, or somebody who wants to go in for modeling, they have to give a portfolio of their own different pictures taken in different poses and all. So that is a presentation of what you have, the IP, the collection of the different intellectual property rights that you own. That is the portfolio.
Thank you, ma'am. Taking in account a young innovator, how difficult or easy is the process of suing in case of an exploitation?
Uh, Difficulty of suing of a, yes, because suing anyone is an expensive procedure. So if you find that your invention is being copied, I would say it is slightly difficult, and particularly in the Indian scenario, Even if you sue the person, how long the courts will take to deliver the verdict and actually give an injunction on it, that is very difficult to predict. It is not really very feasible. And another thing is, it is quite an expensive procedure. So when you find, if you find that there is maybe a large company or a person who is like bigger in terms of revenue or in terms of power, and who is copying the invention, it is a better idea to go in for some kind of a license agreement with the person, or try to sell your patent to the person, so that there is, you reduce the chances of any I would say court matters, because a court matter in India is not a very easy process, that we all know.
Thank you, ma'am. Our next question is, if I ask for the shares in the particular company, does it include IPR costs?
Whether the shares include IPR costs? Yeah, naturally, if the company has a very good IPR portfolio, that is what happens with the big companies. Their share values are much more than the smaller companies. So those shares will take into account all the different assets that the company has. So that also takes into account, like for instance, if Coca-Cola was to sell out its shares, that would naturally be much more than any small company share. That is because it has a very good IPR portfolio. So that is also taken into consideration at the time of assessing the value of the share.
Okay, ma'am. This is our last question for the day. Can a patent be renewed again after it is not renewed for a period of time? For instance, if I got my product patented a long time ago and did not renew it, now I see a potential market and wish to get that renewed to sell it to a company, is it possible?
There is a certain time period within which, if it is not renewed, then it goes into the public domain. So after that, maybe after 2 years, if somebody suddenly wakes up and then wants to renew it, it is not possible anymore, because it is already out in the public domain.
Thank you, ma'am. With this, we have come to the end of our expert talk today. I am sure we all are taking back a lot of knowledge from today's webinar, because being young innovators and also ISM students are coming up with a lot of startups, product based and services based. It is very important for them to know about IPR protection policies. I would like to thank Dr. Indira Banerjee for being with us and delivering a very fruitful session. I would also like to thank Professor Pankaj Mishra, Professor Ajit Kumar, everybody who has been facilitating this session. I would like to thank the whole Faculty Innovation Cell and the Student Innovation Cell. Above all, I would like to thank our audience for being great listeners and posing incredible questions and making this webinar a two-way session. Thank you, everyone. I hope you all are safe and healthy.
Yeah, at the end, I would like to thank Indira ma'am again for accepting our invitation at a very short notice. And ma'am, we will
My
be in touch
pleasure.
with you because we wanted to develop a commercialization policy in our
Okay,
institute. Okay, so
good.
policy document is already there regarding this IPR policy is there, but the commercialization is something which is coming up now, because
Right,
some of the patents which we have filed are now at the advanced level and people are trying to commercialize it. So we
right.
want to develop a commercialization policy because that is
Definitely.
needed at this stage. So
Right.
thank you very much, ma'am. Thank
Thank
you,
you so
Niharika,
much.
for conducting this session very nicely.
Thank you, sir.
Thanks.
Thank you.
That's all.
Thanks to all of you. Stay safe, stay healthy, and a happy new year to you.
Happy New Year to you
Thank
too,
you.
ma'am.
Same